Indigent party. An indigent party is one who has no money or property sufficient and available for food, shelter, and basic necessities for him and his family. The rules provide that a party may be authorized to litigate his action, claim, or defense as an indigent if the court, upon an ex parte application and hearing, is satisfied that the party is one who has no money or property sufficient and available for food, shelter, and basic necessities for himself and his family. Such authority shall include an exemption from payment of docket and other lawful fees, and of transcripts of stenographic notes which the court may order to be furnished him. The amount of the docket and other lawful fees which the indigent was exempted from paying shall be a lien on any judgment rendered in the case favorable to the indigent unless the court otherwise provides. Okay, so any adverse party may contest the grant of such authority at any time before judgment is rendered by the trial court. If the court should determine after hearing that the party declared as an indigent is in fact a person with sufficient income or property, the proper docket and other lawful fees shall be assessed and collected by the clerk of court. If payment is not made within the time fixed by the court, execution shall issue or the payment thereof without prejudice to such other sanctions as the court may impose. So this rule is enshrined in Rule 3, Section 21 of the Rules of Court, authority to litigate as an indigent party. Now there is another provision in the Rules of Court, Rule 141, Section 19, on indigent litigants exempt from payment of legal fees. This rule provides that indigent litigants whose gross income and that of their immediate family do not exceed an amount double the monthly minimum wage of an employee, and who do not own real property with a fair market value as stated in the current tax declaration of more than 300,000 pesos, shall be exempt from the payment of legal fees. The legal fees shall be a lien on any judgment rendered in the case favorable to the indigent litigant unless the court otherwise provides. To be entitled to the exemption provided, the litigant shall execute an affidavit that he and his immediate family do not earn a gross income as mentioned, and they do not own any real property within the fair value mentioned, supported by an affidavit of a disinterested person attesting to the truth of the litigant's affidavit. The current tax declaration, if any, shall be attached to the litigant's affidavit. Any falsity in the affidavit of litigant or disinterested person shall be sufficient cause to dismiss the complaint or action or to strike out the pleading of that party without prejudice to whatever criminal liability may have been incurred. So what is the difference between Rule 141, Section 19 and Rule 3, Section 21 on indigent party? Okay, so when an application to litigate as an indigent litigant is filed, the court shall scrutinize the affidavits and supporting documents submitted by the applicant to determine if the applicant complies with the income and property standards prescribed in the present Section 19, Rule 141. That is, the applicant's gross income and that of the applicant's immediate family do not exceed an amount double the monthly minimum wage of an employee, and the applicant does not own real property with a fair market value of more than 300,000 pesos. If the trial court finds that the applicant meets the income and property requirements, the authority to litigate as indigent litigant is automatically granted, and the grant is a matter of right. However, if the trial court finds that one or both requirements have not been met, then it would set a hearing to enable the applicant to prove that the applicant has no money or property sufficient and available for food, shelter, and basic necessities for himself and his family. In that hearing, the adverse party may adduce countervailing evidence to disprove the evidence presented by the applicant. after which the trial court will rule on the application depending on the evidence adduced. In addition, Section 21 of Rule 3 also provides that the adverse party may later still contest the grant of such authority at any time before judgment is rendered by the trial court, possibly based on newly discovered evidence not obtained at the time the application was heard. If the court determines after hearing that the party declared as an indigent is in fact a person with sufficient income or property, the proper docket and other lawful fees shall be assessed and collected by the clerk of court. If payment is not made within the time fixed by the court, execution shall issue, or the payment of prescribed fees shall be made without prejudice to such other sanctions as the court may impose. Question: when should an application to litigate as an indigent be made? Can it be done while the case is pending? In the case of Ayala Land Incorporated versus Heirs of Lactao, the Supreme Court held that the court finds no merit in petitioner's argument that respondents' claim of indigence was an afterthought because they did not ask to litigate as indigent parties when they filed the complaint or when petitioner moved for its dismissal for non-payment of the correct filing fees, or even when the higher courts passed upon petitioner's motion to dismiss. Upon filing their complaint, respondents paid a docket fee of 6,828.80 pesos, compared to 39,172,020 pesos as allegedly reassessed by the clerk of court and 62,903,240 pesos as computed by petitioner. 6,828.80 pesos is evidently minimal, especially considering that there are 13 individual respondents paying said fee. Take note of this: the Supreme Court held that a party who was assessed a minimal amount in filing fees may opt to simply pay the same, although he may qualify as a pauper litigant. He is not, by such initial payment, stopped from claiming indigence should he subsequently be required to pay additional fees. The court accordingly found no cogent reason to hold that indigence was belatedly raised by respondents. An application to litigate as an indigent party may be made when additional filing fees are imposed subsequent to the filing of the complaint and even after the issue of docket fees had undergone appellate review. So what happens when a party litigates as an indigent and who wins the case? Here is an example: Mactan Rock Industries versus Germo. Germo litigated the suit as an indigent party as defined in Section 21, Rule 3 of the Rules of Court. So the Supreme Court held that it is only proper that the appropriate filing fees be considered as a lien on the monetary awards due to him pursuant to the second paragraph of Section 19, Rule 141 of the same rules. Here is the dispositive portion of the decision of the Supreme Court. Wherefore, the petition is partly granted, and then it stated, finally, let the appropriate filing fees be considered as a lien on the monetary awards due to Germo, who litigated the instant case as an indigent party in accordance with Section 19, Rule 141 of the Rules of Court. What is the rationale of the rule allowing parties to litigate as an indigent? Section 11, Article 3 of the 1987 Constitution provides that free access to the courts and quasi-judicial bodies and adequate legal assistance shall not be denied to any person by reason of poverty. Next question: is this rule allowing a party to litigate as an indigent applicable to juridical persons? This guarantee of free access to the courts is extended to litigants who may be indigent by exempting them from the obligation to pay docket and filing fees. But not everyone who claims to be indigent may demand free access to the courts. In re query of Mr. Roger C. Priorecci, re exemption from legal and filing fees of the Good Shepherd Foundation Incorporated, the Supreme Court held that The exemption may be extended only to natural party litigants. The exemption may not be extended to juridical persons even if they worked for indigent and underprivileged people, because the Constitution has explicitly premised the free access clause on a person's poverty, a condition that only a natural person can suffer. To prevent the abuse of the exemption, therefore, the court has incorporated Section 21, Rule 3, and Section 19, Rule 141 in the Rules of Court in order to set the guidelines implementing as well as regulating the exercise of the right of free access to the courts. Another question: if the litigant is not indigent, should the judgment be annulled for non-payment of filing fees? This was answered by the Supreme Court in one case where it held that the Court of Appeals grossly erred in annulling and setting aside the judgment of the RTC based solely on the non-payment of the filing fees. If the RTC had incorrectly granted an ex parte motion for leave to file case as pauper litigant, the grant was not jurisdictional but an error of judgment on its part as the trial court. It can hardly be disputed that the RTC apparently believed, based on its erroneous application of the aforementioned guidelines set by the Rules of Court, that the applicant was entitled to be exempted from the payment of the filing fees because his daily income was 400 pesos. The Supreme Court held that it is true that the non-payment of the filing fees usually prevents the trial court from acquiring jurisdiction over the claim stated in the complaint. But for the Court of Appeals to annul the judgment rendered after trial based solely on such non-payment was not right and just, considering that the non-payment of the filing fees had not been entirely attributable to the plaintiff alone. The trial court was more, if not exclusively, to blame for the omission. For sure, all that the applicant had done was to apply for the exemption, leaving to the RTC the decision whether or not to grant his application. Moreover, the Court of Appeals disregarded the fact that the RTC, through its order, had granted his ex parte motion for leave to file case as pauper litigant and had allowed him to litigate as an indigent party, subject to the condition that the legal fees would constitute a first lien on the monetary judgment to be rendered after trial.